Justifiable Quickie. John Bad Elk was a tribal police officer with the Pine Ridge Reservation who shot and killed another officer who tried to arrest him without a warrant on an alleged misdemeanor committed outside of the officer's presence. The other officer pulled his gun and Bad Elk shot him in self-defense. By the way, ironically, the other officer was named John Kills Back. Bad Elk was tried in federal district court in South Dakota. Bad Elk requested the court tell the jury he had a common law right to resist an unlawful arrest, but the court instead misinformed the jury, saying he only had the right to resist excessive force. The jury convicted him and sentenced him to death. The precedent goes back to at least 1666 and says that lethal force against an unlawful arrest would, depending on the circumstances, either clear the person entirely or drop the charge to manslaughter. So in April of 1900, the Supreme Court unanimously overturned Bad Elk's conviction. Since there was no excessive force, the Supreme Court ruled what would be murder if the officer had the right to arrest might be reduced to manslaughter by the very fact that he had no such right. So an officer, at common law, was not authorized to make an arrest without a warrant for a mere misdemeanor not committed in his presence. They reversed the lower court ruling and ordered a new trial. Bad Elk died in prison 4 months later before he could get one. He died of tuberculosis, so it's arguable he wouldn't have died if he hadn't been wrongly imprisoned. Now, if you look at scholarly sources, they'll talk about how this is bad law, meaning they don't like it. Legislative acts were passed both federally and in many states saying that citizens must submit to any arrest, even wrongful ones. Of course, these were passed during the height of the civil rights movement as an excuse to sentence activists to death, so there you are. The Supreme Court started going against it in 1925 with the horribly racist, prohibitionist, puritanical Taft Court, which has been the subject of several of these quickies, including decisions that went against freedom of speech, double jeopardy, and others. They ruled in Carroll v. United States that it would get in the way of those wonderful prohibitionist police officers searching innocent citizens to see if they had alcohol. Beginning in 1965, state courts began striking down the right. Nowadays, the right is only recognized in 14 states, and that ended up being upheld in 2001's Atwater v. Lago Vista, which basically said you didn't have Fourth Amendment rights if you were driving without a seatbelt. So nowadays, it's really only recognized if the officer is also using excessive force and it's absolutely necessary to defend oneself. It happens, but it's hardly anything you can depend on, and that's no way for our rights to be.